Okay, welcome everyone to session 9 of Thomson Rogers webinar series. My name is Lucy Jackson and I will be your host. Today's topic is the burden of proof, proving the client's losses and causation. Before we start, if you have any questions, we ask that you please submit using the Q&A button at the bottom of your screen. At the end of the presentation, we'll answer all of the questions you have posed to us. Now let's begin. Presenting today, we have Deanna Gilbert and Robert Ben. Deanna is going to start us off with an introduction to the burden of proof.
Good morning, everyone, and happy Friday to you. Thanks for joining us this morning. So I'm going to be doing an introduction to the concept of the burden of proof. Just to give you a sense of what I'm going to touch on this morning, I'll do a basic review of what is the burden of proof. I will talk to you about the standard burden in a civil case, so in other words, what applies in the medical legal context. I'll talk about some wording and some language that we're hoping many of you folks keep in mind when you're preparing your reports that are used in our insurance cases and our tort cases. I will go over an exception to the standard burden of proof. And then if there's time, I'll segue a little bit into Rob's section today, and he's going to be talking about causation, so I might have a chance to do a brief overview for you in order to segue for Rob. So I'll start first with just talking about basically what the burden of proof is. When we use that term, what we mean is the level or degree to which we have to prove our case or prove a point in order to be successful in the case or on that particular point. So there are different burdens of proof in different legal contexts. You may be familiar with the term beyond a reasonable doubt, and sometimes people who are new to medical legal work aren't familiar that that's a criminal burden of proof. So when a Crown is advancing a case against a criminal defendant, that case has to be proved on the burden of a beyond a reasonable doubt. That is a higher, in other words, a more difficult burden of proof than what we use in the civil context. What we use is the balance of probabilities. And in the civil context, it's typically the plaintiff or the insured who has to meet that burden. So the balance of probabilities in medical legal work generally means the extent to which you have to prove that an injury or an impairment occurred or exists, the extent to which the plaintiff in a tort case passes the threshold, the extent to which a loss has been or will be suffered. The balance of probabilities does not require you to prove something beyond a reasonable doubt. More importantly, and this is where I see sometimes a lot of physicians getting nervous, is it also doesn't require you to have 100% medical certainty. In your clinical practices, you probably are more comfortable giving an opinion to a patient when you're close to having 100% medical certainty. For medical legal work, we do not need that. For the balance of probabilities to be satisfied, we really just need you to be more certain than not, meaning that there's about a 51% chance or higher that your opinion is accurate. You can have not only a reasonable doubt, you can actually have up to 49% in theory of doubt, and you will still satisfy the burden of proof. What's most important to keep in mind for those of you who do medical legal work and write reports is language. Words matter in the medical legal context. When we speak with friends or families, we may say things like, "Oh, I can't believe that." And of course you can believe it, you're just surprised. So a word like can't, you often, those of you who've heard me present before, you often hear me preaching about being mindful of your words when it comes to what I call absolute words. I'm often preaching about how if you write in a report that someone can't do something, it's very different than writing in the report that they rarely do something, because then when there's surveillance of them doing that very thing, there's a big difference between can't and rarely. So that preach you hear from me often. Today I'm going to preach a similar concept. Again, words matter, but in the context of words you're using to describe your opinion when it comes to the burden of proof. Words that help satisfy the burden of a balance of probabilities are words like possibly, words that don't help you. Words that don't help you are words like possibly, maybe, may, or could. So I'll give you an example. If we see in a report, the plaintiff may pass the threshold, or if we see that the insured could be suffering from PTSD, or the plaintiff possibly suffered a loss of consciousness. When you are writing those words, you are killing the case on that particular point. You are saying to the court, this plaintiff does not meet their burden of proof. There are consequences when you write these things. If the plaintiff can't meet his or her burden of proof, or the insured on a particular point, then they won't get the compensation or the benefits that they are seeking in that particular case. So words that do support the burden of proof are words like probably, likely, more likely than not. You can say on a balance of probabilities. You can say will or would as opposed to could or may. Those words suggest to the court or to the adjudicator that the 51% balance of probabilities has been met. So we should hopefully see things like the plaintiff likely suffers from an ankle fracture. It is a probability that the plaintiff is completely disabled, that the insured is completely disabled from performing his activities of daily living. Or the plaintiff will require an ankle fusion in future. Those are things that will help the plaintiff or the insured win the case. Keep that in mind, but there is a caveat, unfortunately, and this is where I think it can get a bit confusing. There is one exception to that standard burden of proof of a balance of probabilities. That exception, and this is the key, only applies to future losses or needs. What I mean by that is future care needs, future risks like whether someone will develop arthritis, a future loss like whether someone will be unable to continue working and will have to retire early, whether someone is likely to graduate university, college, high school, whatever it may be, or even very specific future care needs, whether someone is likely to need a walker in future. For those future risks and losses, if you have to, and they put an asterisk next to that, if you have to, you can resort to a lower burden of proof. Rather than saying it's likely, meaning you've passed the balance of probabilities, you can resort to the lower burden, which is I'm putting this in quotes because it has to be all of these words, real and substantial risk, or a real and substantial possibility. And the reason why I put those in quotes is because you heard me earlier on saying that the word possibility or possibly does not satisfy the balance of probabilities. It has to have the words real and substantial before the word possibility or risk. You must include those words. If you don't satisfy any burden. To get that lower burden for future needs or future losses, it's a real and substantial possibility or risk. What does that mean? I'm sure some of you are probably typing going, well, what does that mean? Can you answer what that means? So what the Court of Appeal has said is that what they're looking for is something that's more than just a fanciful, speculative, or remote possibility. That to them is what a real and substantial possibility is. It means I'm not certain. I can't even say it's more likely than not, but I can definitely say it's not just a fluffy risk out there. There's a real risk to this. I just can't say for sure it's going to happen. Okay? But remember, when you are using that, it's just an exception to the standard likely or balance of probabilities burden. So again, you can only use it for future risks. You must include the words real and substantial. And most importantly, only resort to it where or when you have to. If you think that it is likely that a plaintiff is going to need an ankle fusion in future, if you think it's likely, say it's likely. Just because it's a future risk, it doesn't mean you have to resort to that lower burden of a real and substantial possibility. Where you can, go by the standard balance of probabilities, but if you have to, then you can resort for future risks to that lower burden. Be mindful that when you are resorting to that lower burden for these future risks, you are signaling to the court, you're sending a yellow flag up saying, well, I'm not as confident. This is my opinion, but I'm not as confident. And so the consequence of that is that if there's a expert on the other side who says it's a no-go, then you've made the differences between your opinion much shorter, so it might be easier for the judge or adjudicator to go with the other side. The other thing that courts will do sometimes is that they will reflect that lower confidence in the award and the amount that they're giving to the client. So if an income loss claim, for instance, could vary between $500,000 to $1 million in this particular case, depending on some factors, if your opinion is that it's not that it's likely to happen, but that there is a real and substantial risk, then the court might very well grant the income loss award, but will choose that lower range to reflect that there's a lower risk of it occurring. So in summary, think of the burden of proof as being a spectrum from possibly to real and substantial possibility to a likelihood / probability. And I just want to be clear that this webinar isn't to tell you what to say in your reports. If you don't believe that a plaintiff or insured passes the burden of proof, then absolutely that's your opinion. So we're not trying to tell you what to say in your reports. Rather, the point is for me to try to explain to you how you say what it is that you want to say. And just be mindful that you want to be meticulous and go over your reports before you submit them, because sometimes those words like may and maybe and possibly sneak in there even if you didn't realize it. So I'm going to turn it over to Rob in just a moment. Rob's going to talk to you about the issue of causation. The issue of burden of proof and causation often go hand in hand because they both have to do with the extent to which you need to prove something. Causation is the extent to which you need to prove that the crash or the incident caused what is happening to the plaintiff or insured, or caused that person's losses and needs. So Rob, I will turn it over to you.
Thanks. This is going to be a little bit tricky, and I hope that through demonstrating how tricky it potentially can be, some of you may take away one point, which is this is something that should be thought about carefully and considered very carefully before rendering an opinion. The function of a court in a civil negligence action is really two things: determine liability or fault and assess damages or compensation. It's always a question of causation. On liability, did the defendant's conduct cause the plaintiff's injury? On a question of damages, did the injury cause a legally compensable loss? And as Deanna said, the but-for test asks if a defendant's conduct was a necessary cause, conduct without which the injury would not have occurred. So notice I said a necessary cause, not the sole or the only cause. Every occurrence, after all, whether it's an accident or some other kind of, negligent, conduct, is the result of a complex set of circumstances, background events that help produce the end result. A simple example is darkness may be a contributing cause to a car accident, but the law is not concerned about that so long as it can be shown that the driver's conduct was a cause of the crash. There's no shortage of factual scenarios that we can talk about to illustrate how tricky causation can be. I'll give you one of my favorites here. Two negligently fired bullets simultaneously hit the plaintiff, each of which on its own would be lethal. So neither bullet alone is a necessary cause, because the other bullet, of course, is equally lethal. So the but-for test, or the but-for question, doesn't really work in a simple, straightforward way. But if we look at it more closely, the way the law does, each bullet is a sufficient cause, the presence of which combined with another cause is enough to bring about the injury. But this is a rare case where you've got simultaneous causes, negligent causes. It's very rare. What's more common are successive causes, where one negligent act cause or follows another. A boy stands on the running board of his uncle's pickup truck. The uncle drives recklessly hits a tree. The boy injures himself more seriously than if he had been inside the truck. So it's obvious each of the boy and the uncle's conduct was a cause of the injury to some degree. So the question really is, if both acts were necessary to produce the harm, both were causes when we're talking about successive harms. So, the most important thing when talking about causation on damages or loss, as opposed to causation of an accident, for example, is distinguishing the two, recognizing that they're two different questions. In most personal injury cases, the factual causation or questions on liability are much more easy to deal with than questions on causation of the resulting loss or damages. Questions surrounding the cause of a loss almost always include hypotheticals. What will happen to this injury victim in the future because of their injury? And a more subtle hypothetical, what would have happened had they not suffered the injury? And as Deanna said, on questions of liability, once the plaintiff proves causation on a balance of probabilities, 51%, the law treats that as a factual certainty. But it's not so on questions of loss or damage. The future and what would have been, but for the injury, are indeterminable facts. So it's more appropriate, as Deanna said, to apply a lesser standard of proof, simple probability versus a balance of probability. So it's an evaluation of the risk or degree of likelihood of an unknown fact. And compensation is always made with regard to the degree of risk. But another wrinkle, compensation depends on another important factor, and that's proximity or remoteness of harm. If the loss is too unrelated to the defendant's wrongful conduct, the law will not hold the defendant legally liable for compensation. So here's an example. A man is injured in a car accident for which the defendant is at fault. He gets whiplash and misses some time from work, loses some income. Eventually he goes back to work, but by his own fault, he re-injures his neck and is also diagnosed with a disc herniation. This unlucky man then gets into a second car accident that is a defendant's fault, and he suffers soft tissue injury and renewed pain. He's then laid off from work for entirely unrelated reasons and develops depression and chronic pain. I'm sure all of us here have had cases like this where there are multiple events and factors that may or may not inform a person's loss. But, the law looks at it in a very piecemeal fashion, so to speak. A defendant should only be liable for the injuries that he caused the plaintiff. So in this example, the defendant in car accident 1 caused whiplash. If subsequent injuries like the disc herniation or chronic pain or depression fall within the risk set in motion by the defendant's negligence, then the defendant's liability may extend to those losses. If subsequent injuries that were entirely unrelated to the defendant's negligence are at play, then the defendant obviously should not be liable for them. The same principle applies to injuries a plaintiff may have had prior to a negligently inflicted harm. So an example, a very sad one that we all know about, is someone who has pre-existing trauma from childhood abuse, which is independent from any subsequent sexual abuse they might have suffered. So the law will consider that pre-existing trauma. Back to the car accident scenario, if the injury suffered in the accident is more severe than what would ordinarily have resulted due to a latent vulnerability or susceptibility of the plaintiff, then the defendant remains liable for the more severe injury. You take your victim as you find them, and that's the thin skull doctrine. Your negligent conduct is said to have caused all the injuries that flow from that conduct. If, on the other hand, the injury suffered in an accident is an exacerbation of a manifest or ongoing pre-existing injury, or the acceleration of an existing degenerative process, for example, the defendant should only be liable for the new injury. And this is the crumbling skull doctrine. If subsequent later non-negligent events, like in our example, the layoff from work, which had nothing to do with either car accident, would have created the same losses as the injuries, these events, the layoff, would extinguish the defendant's continuing responsibility for those losses. How do the courts deal with this kind of stuff? I mean, if subsequent negligent events, for example, a second car accident would have created the same losses the plaintiff is suffering as a result of an earlier first car accident, the court may approach it in different ways. One way might be to hold both defendants jointly liable for the continuing losses if the losses or damages are indivisible or can't be divided. Another approach might be to hold the first defendant liable for the losses occurring up to the time of the second accident, and then the second defendant liable for the losses continuing thereafter. Or the court may, on the facts of the case, decide that the first defendant is liable for the continuing losses, and the second defendant is liable only to the extent that his negligence exacerbated those losses. Simple, straightforward stuff, right? No, not at all. Lawyers can get mired in this stuff. Judges can get mired in this stuff. Juries obviously have to struggle with this stuff. So I think the takeaway from me is when a lawyer reaches out to you for your expertise and opinion on causation, whether it be for the injury or for the consequential loss, I think it's really important to speak to the lawyer and get clarity about what standard of proof you need to apply to the particular question at hand. The legal standard, as Deanna said, is not your clinical standard. It's not your scientific standard, particularly where the question relates to an indeterminable future event or an alternative future that the injury victim might have had the injury not occurred. So, just to wrap up, when you're commenting on the cause of a loss, it's important, I think, to outline, compare and contrast pre and post-accident issues in a way that they can be reasonably differentiated. Is this an entirely pre-existing functional limitation the plaintiff is suffering? Has it been aggravated or exacerbated by the accident? Do the plaintiff's indirectly related limitations result from the risks set in motion by the accident or the negligently caused injury? If someone has degenerative process pre-existing, is deterioration of function a result of that independent pre-existing issue, or has it been accelerated or aggravated by the negligent accident? Is the plaintiff a crumbling skull, or is the plaintiff a thin skull? And the considerations go on and on. Each case always turns on its own facts. But again, I think it's very important to understand and appreciate that, these are complicated questions and they do require very careful reflection and consideration of the particular facts of each case. That's all I've got. We could certainly go on, but for the time limit of today's presentation. But certainly if there are any questions, I'm sure that Deanna and I are happy to answer them.
And Lucy, if I can maybe just touch on something that Rob said, from a practical standpoint, when you're writing reports and you're thinking about causation, because I can tell you this is what I do in mediation memos and pretrials, look at the difference in the life stuff. So if someone has had some minor back pain before the accident, they have back pain now, think about, were they on medication before the accident versus now? Was it over the counter, whereas now they're on Tramadol or Oxycontin? Were they working full-time before the accident and now they're only working half-time? Were they in back pain part of the accident but not receiving any massage or any physio or any chiro, and now they are? Were they able to work full-time then and now, except then they also took their kids to swim class afterwards, then came home, made dinner, and then cleaned up the house, whereas now they can only work full time and then they spend the rest of the night on the couch. So when you can't kind of medically parse out the difference, try to look at the functional and lifestyle differences and point those out, because that might lead you to your answer on causation.
Thanks, Deanna, and we can open it up to some other questions now. I know we have one about independent medical examiners and experts. Should the medical examiner and expert address the but-for threshold in the causality section of the report? And if so, what should, and if they shouldn't, what should experts address? How should experts address causality in the reports?
You want me to do that with Deanna?
You go ahead.
So, you know, experts are retained to render opinions that are outside, you know, the common everyday experience of the trier of fact, the jury or the judge. And, you know, one of those questions may be, you know, did this accident cause this injury? I don't think in your report you need to use necessarily the words, but for the accident, the injury would not have happened. You can certainly say that. But as Deanna mentioned, there are a number of different ways to express that. You know, it is more likely than not that the injuries I see here are a result of the, you know, violent forces that you know, were experienced in this head-on collision. Or it's more likely than not. And there's certainly nothing stopping someone from commenting in more stronger language. If it is a near certainty, you can certainly say that. But, you know, if the question is it appropriate for experts to be commenting on that question? If you're asked to, absolutely. I think that's the whole point. The experts are required in particular cases to assist the court in making a determination that is outside the court's expertise. That is an expert's role and function, so it's entirely appropriate to comment on that question.
Okay, thanks, Rob. We've got another question here. Can you clarify between the thin skull and the crumbling skull?
Do you want me to take that, Rob?
Sure.
Yeah.
So a thin skull is someone who, prior to the subject accident or incident, had a particular vulnerability that made them more likely or more susceptible to have a worse outcome from the incident than someone else would. So someone who has maybe even asymptomatic but has degenerative back problems, if they get even a small accident, might have a lot more back pain than someone else who has that same accident and feels fine, feels no back pain because they didn't have any pre-existing weaknesses. That's a thin skull plaintiff. So as Rob said, the rule, as we say, is the defendant has to take that person as they find them. So if you happen to hit that person with the particular vulnerability and they have a much more terrible outcome than had you hit someone else, that's too bad for you, defendant. A crumbling skull is someone who was going to go down that path no matter what. Whether the accident happened or not, they were going to at some point develop the exact same problems, losses, issues that they have that they ended up having as a result of the crash. That's a crumbling skull where, although the accident happened, they're saying at the end of the day, it didn't actually make any difference. This path was going to be followed anyway. So thin skull and crumbling skull are things that plaintiff versus defense usually raise. The plaintiff might argue, well, I appreciate it was just a love tap in the accident, just a little love tap, and that they've got all this back pain, but you have to understand this was a thin skull plaintiff. The defense usually argues, no, this is a crumbling skull plaintiff. This plaintiff, that degenerative back pain, that's progressive. They were going to get back pain whether this accident happened or not.
Great, thanks Deanna, and thanks Rob. It looks like we are out of time. If we don't have any other questions here, I don't see any. So thank you everybody for joining us today. Stay tuned for our next webinar, which is scheduled for Friday, October 23rd. More information will be provided about this webinar on our website. Thank you again, everyone, and have a great weekend.